Okay, let's go.
Johnson Law Group webinar series, Navigating Child Custody in the Best Interest of the Child, presented by attorney Myron Latney.
Thank you very much. This is when anybody asks me why I got into specifically uh, family law, I think I just turned back to being in a space of helping people, right? As we all know, the realities of if anybody's dealing with any custody issues here today, that this is a very challenging moment in people's lives. And having a counsel or having an individual that can truly give you some sense of guidance, I find allows people to get through this tumultuous time at times, right? Much more amicably, much more um, without as much pain, right? And that's what we're really hoping for. And hopefully that when we get through this webinar, we can give you some information and really you can find the value and making sure that you have the appropriate representation if these types of cases feel a bit too overwhelming. I am, again, just like Steph said, an attorney here in Colorado. I've been practicing family law now going on about 10 years or so. I am a resident of Colorado, a transplant though. However, like my bio says, from high asset divorces to these very difficult custody disputes to really just counseling my clients. I've been doing it for quite some time now. And of course, we've been doing it through here at Johnson Law Group. So again, like Stephanie said, we will tell you more about us. I'll tell you more about myself towards the Q&A session at the end. And of course, if you have any questions or want to meet me, don't hesitate to shoot me an email, give us a call. We'll be happy to talk to you guys individually as well. So let's go ahead and go to these next slides, Steph. All right. So when parents separate, children need a plan. Before we really get into legal details, I want to acknowledge something. If you're on this call tonight, you're probably dealing with one of the hardest things a parent can face, right? And that could either be divorce or the reality of custody of your kids or determining custody for your children. These statistics on this slide reflect real families, right? 50% of marriages end in divorce or separation. 90% of custody cases are resolved without trial. Um, but custody, no matter what you're dealing with respect to divorces, custody is by far the most difficult piece often that parents find themselves working through. Not trying to figure out who's going to keep the house, not trying to figure out where the money is going to go. It is the kids. But again, just like I said, the good news there is that 90% of these are resolved without actually going to a trial. And so that means that most parents, even in the ones in the most contentious of cases, ultimately reach agreements that they can live with. And that's important because some of the stuff that, the stuff that you agree today with the parent is ultimately going to shape your children's daily lives moving forward for years. Um, Colorado law is very clear about one thing. The judge doesn't really care about who is the better spouse. The judge doesn't care who filed first. Colorado courts have one guiding question. That's what we're going to talk about today, and that is the best interests of the children. The standard governs everything. And that's what we're going to talk about tonight, is helping you understand exactly how that standard is going to be applied so you can make informed decisions and advocate effectively for your family. And so one more thing is even if you and your co-parent are getting along right now, you still want to consider a legally binding parenting plan. Informal arrangements don't protect either one of you. In fact, I was just in court yesterday dealing with some informal arrangements, and they certainly don't protect your kids. So, without further ado, let's talk about what this actually looks like in court. So, what we're going to cover tonight is going to be four different topics here. First, we're going to look at the best interests of the child. This is actually the legal standard that courts are going to apply, the specific factors that judges weigh, and what judges genuinely want to see from parents when they are determining parental time, decision making, custody, legal custody, physical custody. Second, we'll break down the types of custody. What we have here: legal custody, physical custody, joint, and sole. In Colorado, what this is typically broken down to is parenting time, decision making, shared parenting time, joint decision making, sole parenting time, shared parenting time. Right. Third, we'll walk through building a parenting plan. What every parenting plan must include, how the court approval process actually works, and how mediation fits into that as well. Next and fourth, this one is what parents is always find pretty much eye-opening. We'll talk about mistakes that really hurt your case, that can really hurt your family in the long run. Things well-meaning parents do every single day can inadvertently damage their credibility with the courts, right? So, yeah, while you're building this stronger relationship with your children, or while you're doing things that otherwise even families or parents outside of these spaces would find to be appropriate, when sometimes they're viewed by a judge, they may look at those things differently. And so by the end of tonight, you should have a clear picture of where you stand and what the next steps actually look like. And so we're going to start the foundation with the, or excuse me, we're going to start with the foundation of everything, and that is the best interest of the child or children. So next, best interest of the child, the standard that every Colorado court uses, and what it really makes, and what it really means for your family. This isn't just a phrase. Excuse me. Everything in Colorado custody law or Colorado custody cases flows from that principle of the best interest of the child, right? And this just is not a phrase. This is the legal standard that is codified under the Colorado Revised Statutes. This is section 1410-124. This is something that each and every one of you right now can if you typed in section 14-10-124, I promise you, Google is going to give you some information. But this is exactly what the judges are going to consider and how they want to think about every custody situation, whether that be parenting time or decision making. What I want you to understand is that this standard is intentionally broad and intentionally child centered. It's not about punishing the bad parent. It's not about rewarding the parent who earns more or has more flexibility. It's about excuse me, it is about what arrangement will best serve this specific child's physical, emotional, and developmental needs, right? When a parent understands this, it changes how they're going to approach their case. The question stops being how do I beat the other parent and starts being how do I show the court that I put my child or my children first, right? And so what we have on the screen here are the actual factors that the court is going to consider, or yes, what the court is going to examine when making any type of custody decisions impacting your case, so or your kids. Number one on this list is parents' wishes, right? The parents' wishes is something almost as simple as putting together a proposed parenting plan, right? So if your particular parenting plan is, if your wish is that you see the kids at least 50% of the time, right? That's often a common thing that our parents ask for. Or if it's, hey, I got a pretty strong work schedule. This is the particular parenting plan that I'm looking at. It works around this work schedule. Or if you're in a situation where you've been providing said primary care for quite some time, then perhaps that is the you're requesting and your wishes are that you have this primary parenting time, right? That you have majority of the summer, majority of the school year, right? So those are the things that are looked at when it comes to that particular first factor. With respect to factor two, this is where we're going to get into the child's, excuse me, each parent's willingness to support the other's relationship with the child. If we're looking into each parent's willingness to support the other's relationship with the child, this is one that surprises a lot of people. Judges don't just pay attention to which parent actively encourages, excuse me, judges pay attention to which parent actively encourages a relationship with the other parent, right? They don't just purely focus on everything that you're doing with your child and you making sure that you're getting them to and from school or making you're getting to and from different doctor's appointments and whatnot. They're also going to look in there and say, if this other parent, wants this relationship, or if the other parent reaches out for something like a photo, are you there to actually encourage that relationship? If your child says that they want to see this other parent, right? Are you gatekeeping that relationship, or are you making that child available for the other parent? All right, so definitely a very important factor there. The next one, child's own wishes, if old enough to express preference. That second piece is very, very important, right? If old enough to express the preference. When it comes to three, excuse me, this third factor, or the child's own wishes here, if the child is old enough and mature enough to express a preference, the court will consider it, right? There's no real magic age, but what I found, even through my experience of doing this quite some time, and what I found even through a lot of case law, is they kind of go by this theory of called the rules of sevens, right? And what the rules of sevens ends up factoring into is that when you get to this age of around 14, that's when 12 to 14 or so, that's when this particular preference is really going to carry some weight with the court, with any other third party examiners or experts that may be involved in your case. They're really going to be trying to see for that threshold, excuse me, about 12 to 14 years old. And what's really important about this is that children should never, ever, ever, ever be put in a position of choosing sides. If a child expresses a preference because one of the parents is pressuring them, this will likely backfire, especially if you're represented. This is some of the few areas, or the first areas that any attorney is going to be looking into, to either exploit or to expose, or show the court, because this is one of the few areas that the court is, again, really going to take a keen eye on, or use a keen eye to make a decision of whether or not there is a level of encouragement or discouragement of that particular relationship with the other parent, right? Number four on this list is going to be the child's adjustment to their home, school, and or community. So when it comes to factor four, here, ultimately, the courts strongly really disfavor disruption of a routine. They disfavor disruption of the child's school, their relationships, right? Doctor's offices, if there is a significant need for maintaining a continuity of treatment, right? So this is just an area, if there's family members and siblings, right? So typically, what I find is, if we live in a time where we have what I think some coin as non-traditional relationships, right? And in these non-traditional relationships, you may find that there may be a his, hers, and ours, right? And if you're dealing with a his, hers, and ours situation, the court is going to look into that relationship that the child may share with a sibling, that may not be related to the opposing parent, right? Or to the other parent, for a better phrase, right? So that's something that's going to be looked at when it comes to the child's adjustments to their home, school, and or their community. Number five is discussing each parent's ability to place the child's needs ahead of their own. Right now, this one is also a very important one. Um, but what it comes down to is, I'm sure many of the parents in here today already, you're doing this on a regular basis. But again, this is something as simple as, if, let's say, you know that you have a wedding that you want to attend, but it's your particular weekend. Or let's say that you really want to go to a sporting event, but the reality is your child needs to stay home for because they're sick or something of that nature. They really need to go to the doctor, but you may have some other appointments or you may have some other things that you may need to prioritize. The court's going to look at, are you willing to put some of those other things to the side so you can make sure that your child gets the things that they need, right? And many parents, this is something that it comes relatively naturally. However, this is also something that the court is still going to take its time to examine thoroughly. Okay. Factor number six, history of domestic violence or abuse by either parent. Either parent. So this is not, domestic violence isn't something that has to have a level of police involvement. I come across this all the time. Clients regularly ask me, I didn't call the police. Does this still put me in a position to which there's domestic violence? Do I need to call the police to have domestic violence? No, that we use a different standards preponderance of the evidence. We don't, and even if there's a domestic violence incident between the parties that maybe a party isn't found criminally guilty for, or maybe say it was dismissed because they completed whatever pre-trial programs, domestic violence, anger management, those types of things. When it comes to a civil, custody matter or allocation of parental responsibilities matter or a dissolution of marriage matter with children involved in it, the court is still going to consider that history of domestic violence when it makes the determination of parenting time, decision making, legal custody, physical custody. Okay. Next on the list here, we have physical and mental health of all parties involved. Um, Getting the physical and mental health of other parties and history of domestic, the physical and mental health of the parties, along with the history of domestic violence, is just something that the court is going to have to consider. And by physical, when it comes to parenting time, I don't find that just because a parent may have a physical disability that is automatically, or even a mental disability for that matter, that it's going to really have a major impact on your custody determination. But it's all about the facts, all about your current circumstances, right? If there's parents that literally are disabled and don't have the ability to care for the child, then of course that's something that the court must consider. If there are mental health challenges that actually have impact on your ability to care for the child, that's going to be something that the courts consider. Okay. Next is each parent's work schedule and availability. And or really, I think what I like to kind of combine this one with is your involvement with the child. Um, Everybody operates in kind of different um, structures or relationships, or who is taking on which role. Is one parent taking the child to the doctor, the other one taking them to the schools? Is one parent focused mainly on those kind of administrative, doctor, school, extracurricular, while the other parent is a works more, right? The court definitely comes across these situations, but and it's going to consider it. But what I would say in that is you have to make sure that there's certain things like school pickups or caregiving or doctor's appointments or homework that's being done, that those things are being raised to the court because the court needs to understand the fact that ultimately um, you are involved. And same thing vice versa. If there's a parent that is not doing these things, we need to make sure that those things are demonstrated to the court, expressed to the court that one parent is not doing many of the items or many of these kind of consistent that shows a consistent level of involvement with a particular parent, right? Or it shows a consistent level of bond, right? That you need this time, this mutual support to actually build that level of bond with the child. So that's going to be another factor that the court's going to consider. Another one here with number nine is going to be the geographic proximity of each parent's home. This comes up certainly with initial cases, right? So pre-decree cases. So if it's pre-decree decision, dissolution of marriage, pre-decree allocation of parental responsibility. So that essentially means when the custody orders have not already been entered. When you're going to deal with something like that, the court's going to consider where you live. If you ever talk about relocating, the court is going to consider the geographic proximity of each parent's home when putting together a parenting plan. The best way to break this down is if you have a parent that is living in Fort Collins and we have another parent that is living as far as Colorado Springs, doesn't really make sense to create a parenting plan where each parent is spending that the child is 2 days with mom and 2 days with dad, and let's say a school age child. Does that make sense? Where's this kid who's going to go to school at? So now we got to develop a parenting plan around the fact that maybe this child's school and community is in Fort Collins. Should that parent in Springs now be entitled, or is it in the best interest of the child that it's a parenting plan in which they are splitting their time and on the road for 2.5 hours, 3 hours a day? And believe you me, we find situations where parties come to us and that's exactly where they are. Okay. Number 10, any other factor relevant. And so this kind of goes back to, it's domestic violence. This goes back to the relationships your kids may have with friends and family. This goes back to, concerns that another party may have, criminal convictions. They may have active warrants for themselves, things that really question whether or not it's in the best interest of a child. Or it may turn to just positives. Does a parent have more time to be around a child? Does a parent have more experience or have a better relationship or stronger bond with this child? So when it comes to any other factors relevant, this is truly, truly a catch-all. And what I really want us to take from this is that no single factor determines the outcome. That's why I took my time and went through all 10 of these because each one of them are very, very um, um, strong factors for the court. Well, these are only factors really the court going to consider outside of number 10. And the judges are going to weigh all of these together. The strongest cases I've seen personally, the strongest cases that I've been able to try is when parents are able to demonstrate with documentation and consistent behavior that they genuinely are putting the children first or putting the child first across all of these factors and all of these dimensions here. Okay. And so before I move into the types of custody, I want to open it up for any questions that anybody's here may have. Oh, well, here it is. Can in-laws affect a child custody? That's a really, really good question, Lena. And I would say yes, right? Because again, it goes back to that catch-all. One, we're going to look at, um, I guess, the factor four that we had listed on the slide, which was the child's adjustment to their home, school, and community, right? So they're going to look to see if there is that connection with an in-law. Is a child close with this in-law? How long? How prominent of a member? How important is this particular in-law? Uh, um, how close is this in-law to the child? Yeah, very much so. And that's why I think to your question about in-laws is where we even get into the idea of siblings with that in-law. Um, or again, maybe let's talk about in-laws here. If you're thinking about like grandparents as an in-law, like maybe like your own in-law, will they have an impact on the best interest factors? It depends on, again, that connection. If that in-law never sees the child and never really expresses any desire to see the child, is that something that the court really should be considering? Right? I think I see you typing again. And so I'll answer Lena's follow-ups as we continue rolling through these questions. But let's go ahead and get to topic number two, Steph, if we could. Can you request supervised visitation for them? Well, typically, parenting time is relegated to the two parents, right? Now, interestingly enough, a parent can determine what they want to do or who they want around the child during their respective parenting time. So I think the best way to answer this question is imagine that you're doing a 50-50 situation and you have a particular weekend and you want your child or your children to go to a grandparent's home or an in-law's home or a cousin's home or a friend's home and stay the night. You have every right to do so. When it becomes an issue or a concern is in the event that that particular third party or that person would endanger the child. So that's or endanger their best interests. That is when you start to find that maybe one party or another that raises objections about a particular person. Okay. I see next we have, I see Amanda's typing, asking some questions here. Can a character witness statements be used? Great question. Um, Character
One
witness
second.
statements themselves are a bit more challenging to be used. I think what you're more so wanting that the statements you want them to testify at the actual hearing, right? Because if you're just trying to use out of court statements, you run into a thing called hearsay. And while sometimes there are exceptions to get those statements in, typically the best way to go about using character witnesses are going to be actual individuals, family members, friends, people that have actually observed your relationship and probably can, and it can provide some context surrounding these 10 factors. All right. So let's go ahead and move on to topic two. The next one are going to be the types of custody explained. Here it says, we can bring the slide back up for us, Steph, but it says legal custody, physical custody, joint, sole, and what each term actually means for daily life. The word custody gets used in a lot of different ways by friends, by families, online articles, and much of that is what you've heard may not accurately reflect how Colorado law actually works. Um, the idea of legal custody, physical custody, this really breaks down to in Colorado as parenting time and decision making. Okay. And we still have it listed here on the slide as legal custody and physical custody. But the best way that you can understand legal custody would be that legal custody ultimately means decision making, right? And on the flip here, physical custody means parenting time, right? And both of these when we start thinking about, legal custody here, it's about decision-making authority, not where the child lives. It's going to cover major life decisions, which school the child attends, what medical treatment that they actually receive, their extracurriculars, and at times, which I find to be not as common, but their religious upbringing. Right? If parents find themselves at odds about religious upbringing, this is something that the courts can ultimately examine and make a decision as to whether or not it's going to be joint for every one of these areas or sole. And one big thing that comes up with joint versus sole is the factor that we considered before, domestic violence. If there's domestic violence in a lot of these different relationships, the court is going to be very cautious about whom it actually awards said decision making to. Because the last thing that they want is that a party that may be under the coercive control or under the control of a domestic violence abuser, or someone who's perpetuating said domestic violence, to also be under the thumb, that same person's thumb, when it comes to reaching agreements, or discussing custody issues, or decision-making issues for their kids, right? Again, this is the best interest. Is it in the best interest that parties that are going through this types of, um, albeit rare, but high level of conflict, right? Is it in the child's best interest that they share that decision making? Something that the courts are going to examine. The second part of this is physical custody, as it listed here, but in Colorado, also called, and in the courtrooms, called parenting time, right? It's about where the child actually is going to sleep, where the overnights are going to be spent, where they're going to be living day to day, is a lot of parenting time, right? And this is where you get into that parenting plan. We're going to kind of discuss this in the next slide, of truly determining what type of parenting schedule is in the best interest, again, of this child. And I hope all of you here notice how often I'm saying best interest, because this is how often you should be thinking about this, as you if you find yourselves going through any type of custody issues. Okay. Um, Now, on this list, we have the difference between this joint and primary, right? Joint physical is typically what I like to call shared parenting time. This is going to be in any type of schedule, from 50-50 parenting time. This can be 60-40, 70-30. This could even be 80-20, right? And so, one thing I want to tell everybody in this room, the biggest and the most costly mistake that you can be making when you're kind of going through all 10 of these factors, especially as it comes to that factor one of the parents' wishes, is thinking that a 50-50 relationship, no matter what, or 50-50 parenting time schedule, is in the best interest of your child. If you're a parent and you know that your work schedule does not give you the opportunity to spend the time necessary to make sure that your child is thriving in school or whatever else it may be, then causing yourself stress over the idea of a quantitative number over the quality and the qualitative nature which your child, is going to drive you up a wall. It's going to drive you up a wall. Okay. Um, Same thing a little differently, though, however, is if you find it necessary to have sole parenting time. Typically, these are situations where the other parent isn't present. So if we tied this back into the factors here, this is where there isn't that mutual support, or that parent doesn't have the ability to put the child's needs ahead of their own, or there is this geographic distance between both parents, in which one parent lives in another state, and also their work schedule doesn't make them have the ability to spend much time in the summers or something, or they are relegated to maybe just the summer times, right? Well, that's a little different. You're still in and joint. But still, let's say that there's something going on mentally or physically that give them an inability to promote the best interest of the child or children. That's when the court is going to start looking more into a place of primary parenting time or sole parenting time over your more short shared parenting time or joint physical time. Okay. And another insight on this is that, these two dimensions are completely independent, right? You could end up having joint legal custody or joint decision making with primary parenting time for one parent, right? So just because mom or dad ends up having majority of the time and the other parent is relegated maybe to the weekends, every other weekend, 1 month out of the year, just as summertime, doesn't mean that that's going to naturally correlate to that other parent or one parent making all the decisions or the other parent not having the ability to weigh in on those decisions. Okay. And this is really, a very common sticking point for a lot of our clients, right? So before we move on into the building plan or to the next topic, I want to stop again because I feel like I've been running my mouth here. Do we have any additional questions when it comes to parenting time versus decision making or legal custody versus physical custody? Any questions? And if you do, feel free to throw them in the chat. Stephanie, are we giving them an opportunity? Are we giving an opportunity to ask these questions out loud, or are we just using the chat?
Yeah, we have the chat on, and they can chime in on there.
Okay, okay. So if you have any questions, again, don't hesitate to drop them into the chat. But next, after we've now considered the first topic, the best interest of the child, the second topic, the actual custody, parenting time, decision making. Now we're getting to the place of building your parenting plan. All right. So Colorado requires a parenting plan for every separation involving children. If you get dealing with the courts, the moment you start dealing with these courts, before you're done with your case, there will be a parenting plan involved with your kids. Whether your separation is completely amicable or deeply contested, Colorado requires a written, court approved parenting plan for every family with a child. All right. So, again, whether your separation is completely amicable or deeply contested, again, this is if you're going through the courts. Colorado requires a written, court approved parenting plan for every family with children. It's not optional. A parenting plan is a legal document that becomes part of the court order, meaning violations of it can result in contempt, fines, or even change in said parenting plan. The good news is that courts strongly prefer plans that parents created together with or without attorneys. So when both parents agree on a particular plan, the judge almost always approves it. When parents can't agree, the court creates one for them, and that process not only takes longer, costs more, but gives you less control over the outcome. Right. So in this next topic, I want to walk through what every parenting plan must address and how the court process works. Okay. So a complete parenting plan is going to really address about 6 core areas. One of them here not mentioned, and I imagine that we're going to do another webinar because believe you me, it can take a whole week, and that being child support. But a excuse me, the first core area that a parenting plan is going to include is going to be the regular weekly schedule. So a regular weekly schedule, the question that you should be asking is which night does each parent have a child? This is pretty much the backbone of the entire plan. The default schedule the default schedule or the regular schedule is going to govern pretty much the ordinary weeks. And the best way that I like to, to break up the difference between regular holiday and vacation or summer is regular for school age children is when they're in school. That's going to be your regular parenting time, right? It's going to determine who's doing the pickups and drop offs. It's going to determine the locations of these pickups and drop offs, and it's going to determine who's providing transportation on particular days, right? One plan that we see often is what's called what do they call a 5-2-2-5. One parent has Monday and Tuesday, another one has Wednesday and Thursday, and they alternate the weekends. So that regular schedule is going to be in operation during that time period, right? During for Monday, Tuesday, Wednesday, Thursday, Friday, during the regular school year. The next one is holidays and vacations. Um, Holidays are going to be your Christmas break, Thanksgiving breaks, or Christmas Day, Christmas Eve, Hanukkah, whatever religion that may have its own holidays that you observe is also something that can be considered. Right. Again, this is why it's really important that both parents in either parent truly put their thought and input into these holidays or into these schedules. And typically, the way this works when it comes to the holidays and vacations, is that these are going to take precedent over your regular parenting time days, right? So when Christmas break comes up, the Christmas break parenting time or schedule is going to take precedent or is going to be primary before the holiday or your regular weekends. If Mother's Day weekend comes up and that's in your parenting plan, that mom is going to have the entire Mother's Day weekend, even if it falls on dad or another family member's parenting time, it's still going to break down to with one where that holiday is going to take precedent. That holiday is going to be primary, right? And the same thing with vacations. This is something that can be built into a plan. Typically, we see things like it may be relegated to the parties, may take a 2 week vacation during the summertime, or it may be relegated into or included in here where a parent may be able to take two different vacations throughout the year and it must be on their respective parenting time. There's so many different ways that this can actually be created in a parenting plan as well. Another core area is going to be communication between parents, how the parents will communicate about the child. Some parents are doing just fine with text messages. Some parents need to use more formal programs, things like talking parents. And sometimes we find ourselves with, very contentious parents and have to use something even stronger, things like civil communicator, right? But most of the time, the parenting plan is going to outline also whether these communications need to be in writing, whether these communications can be verbal. If there's emergencies, should that conversation automatically be allowed to be in writing? Should somebody not be able to reach somebody via one of these platforms? May they be able to communicate via email, text, or any other thing? If there's an emergency that pops up, how do the parents communicate those particular emergencies? All of that is typically covered as far as the communication between the parents. Next is going to be that decision making that we were just talking about. That parenting plan is going to break down how the decision making is going to work, and you're going to have your major areas. Typically the major areas that you're going to be considering, just like I said before, are going to be your medical treatment, education, extracurriculars, and at times religion. Now, the reality about major decision making is that if there are other major decisions that need to be made for a particular child, those can be addressed as well. But those four that I just listed are typically the areas that have to be addressed in every single parenting plan. And the fifth one here is relocation provisions. What happens if one parent wants to move? That is something that comes up more than not. How are we going to go about that? So typically Colorado requires advance notice, right? They're going to require that you reach out to the parent, that parent, that you two try to have a conversation to see how you're going to work out your parenting plan. And of course, if you can't agree, the court's going to have to make that decision. But in either situation, if there is some type of relocation, especially after a parenting plan has already been filed with the court, there typically must be court approval on that relocation. So that could be the parents reaching an agreement. If they reach that agreement, it needs to be filed with the court, right? If not, you parties run the risk of not being able to enforce that, as we mentioned earlier, informal agreement. Okay. The last, but certainly not least, of these, when it comes to purely parenting time and decision making. And again, if any of you have any questions about child support, I'm sure we're going to be doing another webinar where we get much more deeper into child support itself. But it's going to be dispute resolutions. How will future disagreements be handled? Most of pretty much all of these are going to require some type of mediation before going back to court. But in some high conflict cases, there may be a parenting coordinator, right, which is a neutral party that has the ability to assist the parties with implementation of their parenting plan. Then you have what's called a decision maker, right? And that's another neutral third party that actually has the authority to make certain decisions, and they're binding, right? And so those, again, those are things when you start getting to that high conflict, a parenting coordinator or a parenting coordinator slash decision maker, when you start getting into that level, you really, 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 really want to start truly considering hiring counsel, because now you're getting to a level that can be relatively daunting, to say the least. Um, yeah. And so after you kind of you go through these parenting plans, and all the parent in every parenting plan that must, excuse me, every plan must address these six different areas here. Now I want to kind of talk about like the court process itself, right? First, you're going to have to file for a separation or a divorce, or also can be a custody matter, which is called allocation of parental responsibilities, right? So it's going to either be that filing of a separation, filing of a dissolution of marriage, or filing of an allocation of parental responsibilities. The moment that these three things are filed, it's going to formally put this issue before the court. Next, if we find ourselves, or if you find yourself in a situation where you cannot come up with a temporary schedule, if you cannot come up with a parenting plan that you two are going to, that you either agreed to or that you're going to implement while we get ourselves down to that final orders at number 5, the court will consider a temporary orders hearing. Here, this is where they can establish a temporary parenting time schedule and a temporary decision-making order, right? That temporary parent time schedule can be that every other weekend or a week on, week off. A temporary decision making could be given one party sole decision making until a thorough investigation is done on another party's mental health, or until an investigation is done to determine, how involved one party is, or, if there's been some type of domestic violence, the court may want to examine that further, or give a party an opportunity to rehabilitate themselves a bit before getting to those final orders. All right. The next one is mandatory mediation. You may have heard me say this previously, but pretty much every time you deal with these cases, there's going to be mediation, right? Nearly every time. The court really pushes mediation because, as we said before, this is a real good opportunity for the parties to come eye to eye, to meet eye to eye, and find a plan that truly meets the best interests of their children, that specifies exactly what the best interests of the children are. They go into some of those details that one may not always, that a judge may not consider. I tell my clients this pretty much all the time. You know, Do you really want the DMV making decisions regarding your kids? That's why it's always important that if there is a thread for you two to communicate and try to reach an agreement in mediation, you certainly do so. After mediation or during mediation, kind of either or even before mediation, the parties or the parents will draft and submit that parenting plan that we were talking about in topic, and what that I guess we still are talking about here in this topic here. But that parenting plan of all those six different areas that we were discussing just previously, that's going to have to be drafted. That has to be submitted. And like it says here, ideally, these are created together, right? And then the last of this is the final orders. If the parties can reach an agreement, the judge may review that parenting plan and issue a final order on it. If the parties cannot or haven't reached that final agreement, then this is where you get into a place where you have to go to a final orders hearing. The court will listen to both sides after listening to and go through those best interest factors that we discussed. Consider the different witnesses, Amanda, that you brought up. Consider those in-laws and those different requests, Lena, that you raised, right? And they're going to make the determination of what is the best parenting plan. This may turn into one party having one plan and another party having another. And the court reading both of those, hearing the evidence, and ultimately determining which one is in the best interest, or the combination of the two. How is that in the best interest for the clients, or excuse me, for the children or the child, right? So before I leave this topic here, I want to open up again for some questions, some Q&As. All right. And again,
I think
we'll
we've
open.
got, sorry, I think
Yeah.
we've got a question
Okay.
from Imelda. I'm dealing with a post-decree Colorado family law matter, which I was limited to supervised parenting time of 2 hours per week,
Mm-hmm.
uh, with no logistical specifics and in a different country. In practice, this left her without physical parenting time for over 30 weeks,
Mm-hmm.
only phone calls supervised by the other parent. The case also involves lack of cooperation, barriers, and filing restrictions requiring counsel that she's having a hard time um, finding the funds for. So,
Yeah.
any recommendations on that?
Yeah, definitely one of those situations that, start looking into wanting representation for, number one, because you can see the moving parts there. Number two, if this is a post-decree motion, it sounded like if there's any type of supervision, or if you've been relegated to supervised parenting time, that this likely came at the heels of a restriction hearing. And typically, when a parent's time has been restricted, the court, one, either offers a opportunities and or just avenues to get your way back from out of an unrestricted space. That may be, as simple as just conducting your supervised parenting time as much as possible, to just kind of build that bond back, and maybe doing whatever treatment that may need to be done behind the scenes. Sometimes you find restrictions of parenting time when there may be, again, domestic violence that's involved, and the court may want to be some domestic violence classes to be taken, whether there's concerns of substance abuse, whether there's a lot of different things can lead to restricted parenting time, abuse concerns between the parent and the child, a lot of different things. However, I think what's important for you, Amelia, in your situation, or Amelda, in your situation, is to know that, or in that situation, is that there can also be a review hearing, right? So if you're finding yourself in a situation where the opposing, or the other parent is gatekeeping and not even allowing these supervised visits and allowing an opportunity to get back to a place where you can potentially request the removal of these restrictions, then it's certainly worth bringing to the court's attention. Right. And so ultimately your goal there, if that person's in another country, you may not find yourself with the ability to get to a um or either one of you get to a 50-50 parenting plan. But ultimately the restrictions at some point, if you can make sure you are handling the maybe underlying concerns raised by the court, um, should be able to get you back to a place where this time is unsupervised and the phone calls are also unsupervised.
Thank you,
Good
Myron.
question. No problem. Great question. Any other questions?
Not at
No?
this
All
time.
right. So we want to get to kind of our final topic here is mistakes that hurt your case. Um, this is the slide that I wish every parent actually could see before they make any of these mistakes, because I truly do see them in my practice constantly. And they can really derail an otherwise really strong case, or a case that can be demonstrated relatively easily. The first mistake that we typically find is bad mouthing, speaking negatively about the other parent to or around the child or on social media is one of the fastest ways to lose credibility with a judge. So, whether this happens in front of a child on social media and texts that end up in exhibits, or we got somebody waiting in the lobby here, or what do we have here? I'm sorry, I lost my train of thought.
Bad mouthing a
Or in
parent.
conversations. Yeah, yeah. So these can be text messages, social media posts, bad mouthing in front of a child, or conversation that your child overhears and repeats. It can damage you, right? Judges are acutely aware that a parent who undermines the other parent is by definition placing their own emotional needs above the child's needs. Goes back to that factor that we were talking about earlier, right? And that is opposite of what the best interest standards requires. So for everybody in here, please, 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 be cognizant if you're dealing with this type of matter to not badmouth the other parent, and be very cautious about some of the things that are said or repeated, even by a third party, right? If there's an in-law that often has something negative to say, or if there's a grandparent that often has something negative to say about the other parent, we want to be very cautious that that child is not around to hear those things. Because a simple rule of thumb is, if you wouldn't want the judge to hear it, don't say it, not to your child, not to a mutual friend, not online. Because the only person that you're going to be able to control is yourself in these situations, and not that a parent or somebody else is going to end up repeating that to the masses, that finds its way in front of a judge. Mistake number two is withholding of parenting time, refusing or limiting the other parent's time without a court order, even over a genuine concern, can result in contempt of court. So I understand why parents do this. Sometimes there's a genuine concern about the other parent, but unless there's an immediate safety threat and you have a court order protecting you, unilaterally withholding the parenting time can be a violation of a parenting plan, or put you in a position in which the court really questions your ability to encourage that relationship with the other parent. And if you find yourself with a parenting plan that's in effect and withholding that time without a court order, that can really be a violation of the parenting plan itself, and can result in you being held in contempt and a finding being entered against you. Okay, so be cautious. I don't care what gender norms that we all, kind of maybe understand. Again, if you're on this call, you're probably dealing with some type of situation like this. I don't care what the gender norms and what society tries to tell us about withholding parenting time or who should be the better parent. The court is not looking at the spouse. They're not looking at the gender of the parent. They're not. They just want to make sure that if there's any type of withholding, doing so has either gone through the courts if there's a parenting plan, or doing so is as the result of an immediate safety issue. And you're doing so again for the best interest of the child or the children. Mistake number 3, and this is really like a really big one too. Relocating the child outside of their agreed area without proper notice or court permission is a serious violation that can result in the child being returned. If I had a nickel for every time I've either had to say this or every time that I've had to deal with this, I don't know if I would be doing this webinar right now. As much as I love it, Stephanie, I just don't know if I would have to do it because this is a constant thing that pops up. Either a question that I get from clients, and it's just a reality of the world that we live in today. People are much more transient. They will feel like they need to get up and go to another state for opportunities, for school, for work, for educational opportunities for your kids to bring you closer to family. So if this does come up in one of your situations, don't panic, right? I think it's about just going through the process and knowing that this is going to be something that the court ultimately needs to make a decision on. All right, because if you're doing so without proper notice or without court permission, you are potentially committing parental relocation without authorizations, and without authorization, and courts take this very seriously. So, when it comes to the parents' order to return the children, this could look like a motion for abduction prevention, a motion to return the child, and imagine being 1,000 miles away and the other parent files a motion to return and the court sets the hearing 2 days later. And if you don't, they you have a chance of being held in contempt or worse. So be very careful when it comes to relocating without court approval. And even if you and the other parent agree, this kind of goes back to something I said earlier. Informal agreements are not enough. You can have notice, you can have that informal agreement, but you need to reduce that informal agreement to a formal order, a court order through the court. Okay. Next is putting kids in the middle. This is probably one of the biggest mistakes, probably the mistakes that can happen without trying, right? With the best intentions. You are using the kids as messengers, interrogating them after visits, or making them feel responsible for adult problems causes lasting harm. Judges know that. Oh, I don't want to go to dad's house this weekend. I'd rather stay with you, mom. Oh, mom says, call your dad and talk to him about it. No, that has to be a conversation amongst parents because what you have done, while it may make sense in a more traditional home or when both parents are in the same home, but what you have now done is put that child in the middle of a situation, of a decision that should be addressed between the parents, right? So that's definitely something that you want to stay away from. Um, and again, when it comes to interrogating after visits, this is going beyond just simply asking, how was your time with the other parent? Who was in the home? What did you do? Why did they do that? Are you safe over there? Why? What's going on with this person? Before you leave, make sure you call me. And the whole time that you're there, I'm gonna check in on you multiple times. And what did you see that other parent say? What did they say about this person? Try to avoid it as much as possible. If it's something that you hear that really rises to a level of a concern or rises to a level of immediate danger, reach out to that other parent. Consider filing that motion to restrict, but definitely try to do so with avoiding putting the children in the middle of it. Because the reality is, in the high conflict custody cases, the kids are significantly at risk for anxiety, depression, academic struggles. The courts know it; they're watching for it. And a parent that demonstrably protects their children from adult conflict is going to show to have a meaningful advantage than the one that's consistently throwing the parent into said adult conflict. Okay. So honestly, I tell my clients the plans have expiration dates since circumstances can change a lot over the time. Give me one second. Great question, Amanda. Give me one second. Let me read this last little bit. But I tell my clients that the best thing that you can do for your case is also the best thing you can do for your children. Act in a way that prioritizes them consistently and in ways that can also be documented. Right. Now, to your question, do plans have expiration dates? The only expiration date that a parenting plan is going to have is one when the child turns 18. At that particular point, the real reason why they expire at that particular time is that the court typically does not have jurisdiction over that 18-year-old because for the purposes of the parenting plan itself, not child support, but of the parenting plan itself, that child is no longer a minor. So basically, it's like imagine trying to tell this 18-year-old that you have to go to your dad's house. The court can't make that 18-year-old do that. So that is pretty much the only times that parenting plans, quote unquote, have expiration dates. Other ways that the parenting plans could be obsolete is if the parents informally kind of go against the parenting plan and no longer use it, or the parents move and don't file it with the court and they're kind of just operating under a completely informal, different parenting plan. That would be like the only other scenario in which I'll see that the court likely would come back and look at the current um, um, behavior or the current routine schedule, informal schedule that the parties may be implementing. But for as far as true expiration dates, the only time that you're looking for is when that child hits the age of majority. All right, great question, Amanda. Any other questions? All right. So next, get the next slide. Why Johnson Law Group? We don't practice other areas of law, right? Every attorney here, every case, every day is focused on Colorado family matters, right? Including custody, divorce, and parenting matters. Um, we are going to take a child first advocacy approach. Um, One thing that I've learned in this practice, which I've been doing for quite some time, is that when attorneys understand that custody cases are about the kids and not about winning, we can actually assist a parent with building agreements that work for their families, right? That work for the kids, that support the kids' best interests. When either parent is worried about winning 50-50 time, and I really say that even with that face, winning, what are you winning when you found yourself in this particular place where you and the other parent ultimately can't reach an agreement, right? And then going back really to us focusing on family law, it matters because family law is very complex and constantly evolving, right? I mean, for instance, child support has seen a major overhaul that typically the took all the attorneys to come together and really review. Reviewing court orders or following appeals is a completely different process than it was even within a month ago. So when your attorney handles custody and parenting matters every day, they know about the local judges, the court clerks, the local procedures, the practical realities that general practitioners or people that don't practice primary family law don't encounter. It shows up in that courtroom. All right. Um, then again, I don't want to go into the child advocacy too much more, but again, that perspective, that keeping the child first is really going to shape everything that you do, and shapes everything that we do here, and it shapes how we truly negotiate and prepare for hearings alike. Okay. And then lastly, we have 5 locations across Colorado. We have Denver, Colorado Springs, Commerce City, Inglewood, Fort Collins, and we also serve clients up in Wyoming. So we're positioned to serve families across the Front Range, whatever you are. So don't hesitate if you find that you have an issue that needs to be addressed. Don't hesitate to reach out to us. Um, After tonight's Q&A, I'd like to encourage each one of you to take up on our free consultation. It's 30 minutes with one of our attorneys, no obligations at all. We can give you some clarity about the specific situation that no webinar is going to be able to fully provide, right? If you can sit down with me for an hour, sometimes you can sit down with me for 2 hours. I'm not going to be able to get through all of this because each one of your cases are unique. Each one of your families are different. Each one of your kids provides a different mindset, or a child advocacy, a child first mindset um, that really requires us to dive deep into your family's lives, right? To really have those conversations.